Yep. Gotcha.
Cool. And there was one cool
RO. Yep.
Got it.
Allison, an RO is a registered organization, which is the topic we're talking about. In New York, there are 10 registered organizations. That's our medical marijuana operations. And so a registered organization is able to, one, sell marijuana at the medical level. And then, as we'll see in this bill, they're also allowed to bid into or basically pay into the OCM's reinvestment fund in order to get adult use licenses. We'll talk about how many licenses they're allowed to have for retail locations and just kind of what that's going to look like. So let's keep going. Jason Cotton.
Section 40, relation to other laws, the provision of this article shall apply except that where a provision of this article conflicts with another provision of the chapter, this article shall apply. So all that's saying is Article 3, if it conflicts with another article, Article 3 trumps. Medical cannabis shall not be deemed to be a drug for purposes of Article 137 of the Education Law. Home cultivation of medical cannabis. I know a lot of people are interested about this. So certified patients 21 years of age or older may cultivate cannabis for personal use. Designated caregivers 21 years of age or older caring for certified patients either younger than 21 years of age or whose physical or cognitive impairments prevent them from cultivating cannabis may cultivate cannabis for use by such patients, provided that no other caregiver is growing for said patients. All cultivation under this section shall be in accordance with section 222.15 of the penal law and any regulations made by the board, provided that the maximum number of cannabis plants a designated caregiver is authorized to grow is proportionally increased for each patient they are growing for. Remember, though, that a caregiver can only care for 4 patients. So really you're talking about like a maximum of like 24 plants, 12 mature, 12 immature for a caregiver. All right. Protections for the medical use of cannabis. Certified patients, designated caregivers, designated caregiver facilities, and employees of designated caregiver facilities, practitioners, registered organizations, and the employees of registered organizations and cannabis researchers shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege, including but not limited to civil penalties or disciplinary action by a business or occupational or professional licensing board or bureau solely for the certified medical use or manufacture of cannabis or for any other action or conduct in accordance with this article. Being a certified patient shall be deemed to be having a disability under Article 15 of the Executive Law, Section 40C of the Civil Rights Law, Sections 240, a whole bunch of penal law stuff. Basically, you are disabled for under the New York State Human Rights Law. It's kind of like the same disabled under the Americans with Disability Act, insofar as you employers or such must make reasonable accommodations under the law. Reasonable accommodations has a legal definition. But just know that you do get heightened protections if you're a medical patient. Let's see. This subdivision shall not bar the enforcement of policy prohibiting an employee from performing his or her employment duties while impaired or by a controlled substance. This subdivision shall not require any person or entity to do any act that would put the person or entity in direct violation of federal law or cause it to lose federal contracting or funding. So, you know, just like alcohol, for example, you can't go into work drunk, you can't go into work high. They can take action even under this if it's impairing your abilities to do your job. Also, if it causes federal contracting to go away or violates federal law, like a very common one is U.S. Department of Transportation regulations if you're like a truck driver or something like that. So know that there are limitations because the state can only control what's within the state law.
Jason, do you think there's any room to argue in that the language around impairment, as we've discussed, cannabis impacts everybody differently? How do you think they'll be able to measure that?
I think it's going to be facts and circumstances, documentation. If you're an employer, let's say that an employer is on this call and they're sitting there thinking to themselves, oh, okay, well, I don't mind if my employees use outside of work, but I'm concerned about what they maybe do inside of work and how to document that. The best thing to do is A, talk to a good employment lawyer, and B, document. That's how you build your case. If you're looking to take action against somebody, is what you find to be an impairment or things like that. And, it becomes a facts and circumstances analysis, but it's a very tricky position because, disabled under the human rights law or ADA, if it was not medical cannabis, is very hard to navigate for employers, and it's fraught with potential liability. So, you really do need to talk to a good employment lawyer, labor lawyer, who can kind of guide you through the maze of what that means, what's a reasonable accommodation, and things like that, because, and it's probably, down to also the facts and circumstances of the job. If you're a line cook, for example, versus, I don't know, take me, for example, like an attorney, impairment may be very different in terms of what impairs one of us to do our job versus the other or something like that. So it really does become a very specific analysis. And it's tough for employers. It really is. It definitely, errs on the side of caution for protecting the employees because they are considered disabled and it's a medical condition. But there are obviously going to be times where it comes up. I've been involved in some like adverse determinations for employment insofar as like a medical patient being denied a job because they were a medical patient because they tested positive. That wasn't even an impairment issue. That was literally failing a drug test and the employer was just wrong, and the New York State Human Rights Department found against the employer. So yeah, I would definitely say it's something that you need to talk to a lawyer about, because trying to navigate it yourself if you're not a professional is very, very difficult. Okay. The fact that a person is a certified patient and or acting in accordance with this article shall not be a consideration in a proceeding pursuant to applicable sections of the Domestic Relations Law, the Social Service Law, and the Family Court Act. Certification applications, certification forms, and any certified patient information contained within a database and copies of registration identification cards shall be deemed exempt from public disclosure under sections 87 and 89 of the Public Officers Law. Upon specific request by a certified patient to the office shall verify the requesting patient's status as a valid certified patient to the patient's school or employer or other designated party to ensure compliance with the protections afforded by this section. Name, contact information, other information relating to practitioners registered with the board under this article shall be public information and shall be maintained on the board's website, accessible to the public in searchable form. However, if the practitioner notifies the board in writing that he or she does not want his or her name and other information disclosed, the practitioner's name and other information shall thereafter not be public information or maintained on the board's website unless the practitioner cancels the request. I think we had talked about that before, where New York State Department of Health has all the listed certified physicians and care and certified, people who could certify, but you can, as the physician or whomever, request that you're not on that list. So the list is definitely not all encompassing. A person currently under parole, probation, or other state or local supervision or released on bail awaiting trial may not be punished or otherwise penalized for conduct allowed under this article.
So that's a big one for social justice reform. It's been really touted as a big success from a lot of folks in the community who've been advocating for the rights of those who have been under parole, probation, to really kind of disrupt the cycle of punishment with regards to cannabis use, specifically in this case.
And remember, though, this is in particular to medical. So if you're a medical patient, and I don't recall what the adult use side of it is, though I imagine it mirrors it pretty well. But this is for medical specifically. If you're one of those people, can't be an adverse fact against you. Employees who use medical cannabis shall be afforded the same rights, procedures, and protections that are available and applicable to injured workers under the workers' compensation law or any rules or regulations promulgated thereunder, when such injured workers are prescribed medication that may prohibit, restrict, or require the modification of the performance of their duties. I think I remember seeing out of the 3rd department, which covers like Syracuse, Adirondacks area, like central New York, they required an employer to cover medical marijuana because the physician had said, this helps the patient, and the employer didn't want to. And I'm pretty sure the 3rd department, and this is relatively recent, I think it was in the last 6 months maybe, basically said you had to. The law is constantly evolving in that. Regulations, the board can promulgate regulations, and the Cannabis Advisory Board may make recommendations. Based upon the recommendation of the board, executive director and or the superintendent of the state police, that there is a risk to the public health or safety, the governor may immediately suspend or terminate all licenses issued to registered organizations. Pricing, registered organizations shall submit documentation to the executive director of any change in pricing per dose for any medical cannabis product within 15 days of such change. Prior approval by the executive director shall not be required for any such change, provided, however, the board is authorized to modify the price per dose for any medical cannabis product if necessary to maintain public access to appropriate medication. I wonder if that's foilable, freedom of information law, because I'd actually be curious to see what the ROs are submitting to regard to pricing. I think that'd be interesting.
Very interesting. Hey, Jason, is it clear when I talk or is it laggy?
So far, it's okay. You haven't been too distorted.
Okay,
Really been distorted.
All right, cool.
All right, so Article 4. This is the one that I think most people have been waiting for. So we'll dive right into it. Elise, do you want to start, or I can continue?
Sure, let me kick you off. Okay, so license application. Any person may apply to the board for a license to cultivate, process, distribute, deliver, or dispense cannabis within the state for sale. Such application shall be in writing and verified, shall contain such information as the board shall require. So that's important, right? That means that the applications will not be online. That's something that you have to remember. When people were applying for the medical marijuana applications, they had to like drop off these massive booklets down to Albany. Okay, so such application shall be accompanied by a check or a draft for the amount required by this article for such license. If the board shall approve the application, it shall issue a license in such form as shall be determined by its rules. Such license contains a description of the licensed premises, and in form and in substance shall be a license to the person therein specifically designated to cultivate, process, distribute, deliver, or dispense cannabis in the premises therein specifically licensed. So a separate license shall be required for each facility at which cultivation, processing, distribution, or retail dispensing is conducted. What that means is if you're going for a production and a processing license, which you're going to be allowed to do under this bill, each will have their own separate license that you'll have to remain compliant with. So it won't be like you can apply. I mean, it'll probably be one, it might be one entity, it might be two entities, depending on how you're going to structure your company, but you're going to have two different licenses. So an applicant shall not be denied a license shall under this article based solely on conviction for violation of 220 or section 240-36 of the penal law. Prior to the date article 221 of the penal law took effect, a conviction for a violation of article 222 of the penal law after the effective date of this chapter. Information be required in applications for licenses is basically this blanket of authority. The board shall have the authority to prescribe the manner and form in which an application must be submitted to the office for licensure under this article. For those curious, we're most likely going to see, and it's point 2 here, the rules and regulations come out. We're expecting to see it at the end of August, first week of September. I've talked with a few different regulators and legislators, and they're saying that they're trying to get everything wrapped up by the end of the year. And in order to do that with a 45-day and a 60-day comment period, we have to see those by the end of summer. So the board is authorized to adopt regs, including emergency rules, establishing information which must be included on an application for licensure under this article. So such information may include, but isn't limited to, the identity, including your racial, ethnic diversity, ownership, and investment information, including the corporate structure, evidence of good moral character, which means you might need to get like character affidavits from people, including the submission of fingerprints by the applicants to the Division of Criminal Justice Services, information about the premises to be licensed, financial statements, and any other information prescribed by regulation. All license applications shall be signed by the applicant, if an individual, by a managing member, if a limited liability company, by an officer, if a corp, or by all parties, if it's a partnership. Each person signing such application shall verify or affirm it's true under the penalties of perjury. All license or permit applications shall be accompanied by a check, draft, or other forms of payment as the board may require, or authorizing the amount required by the article for such license.
Hey,
If
so
there are
what's sorry to interrupt you. What's a draft?
No.
That's something that I am a little naive to. When it says accompanied by a check, a draft, or other forms, can you remind us what that means? Or
I mean, like a draft is probably like draft from your bank account, my guess.
yeah, interesting.
Jason, I mean, I don't know. I think it's most likely a bank account.
Yeah, I think
Deposit
it's
from
very
bank.
similar to like a check.
Yeah.
So, yeah, basically you're paying by written instrument. I don't think they're accepting credit cards.
Yeah, a bank check. Yeah, thanks, Laura. Yeah, it's the same. I think, yeah, it's just a connection to a certified check to your bank account. Yeah. If there are any proposed changes after the filing of the application or granting of a license or permit, and any of the facts required to be set forth for such application, a supplemental statement giving notice of such proposed change, costs and source of money involved in the change, duly verified or affirmed, shall be filed with the board at least 30 days prior to such proposed change. So failure to do so shall be willful and deliberate. So that's important, right? Say, for example, you apply with a bunch of investors and your one investor is out. You have to immediately notify them of the change and whether or not you're getting new money or what. And obviously, if there's a change substantial, which would mean like, say you're applying a social equity, but you lose an operator that might have qualified you for it. It's a big change that would probably affect granting your license or not. So stuff to think about. And mind you, it might take a while for them to grant these licenses. So you might apply, it could be 6 months, 7 months, 8 months before you get the license, if you do get one. And a lot can happen in that time.
That's a really important point too, that I don't think, we've covered, or a lot of people are talking about, is that, we're talking about the regulations and by the end of the year, and then maybe applications, but then what's that period of time between the application process and what licenses started being granted? And yeah, we don't know what that lag could be, but I mean, I've seen some articles, and I don't know how reliable they are, that are estimating that legal sales wouldn't start till 2023. So, who knows what the timeline is right now?
Yeah, I mean, I think we're going to see sales come out of the medical marijuana ROs pretty quickly after the rules and regulations are done.
I agree.
But what I think is difficult, right? If they don't license you pretty quickly after you put your application out, not only is that a long period of time, but then you have to get into construction. So, for example, you're not gonna start construction before you're licensed, especially because we don't know how many people are going to be licensed, and if it's a canopy cap, if it's a retail cap, or what have you. So you don't start any of the things to get your business up and running. So then you'll get your license, and that could be another 8 months to get your construction done. I mean, processing construction takes a really long time.
There was even something with regards to like the new hemp bill that's just got pushed through, and it talks about, you have to prove that you're going to get after you get your license, you'll have to prove that you're able to get your GMP certification within 6 months.
Yep.
And just thinking about like how many steps, if you're pre-build to get this CGMP certification, is impossible. Now, it's not proposed. I haven't seen that language for adult use, but it's just
we'll
that
see
same
that
level.
though in the rules and regs, Zach. So that'll be a rule and regulation. So totally, that's a very hard level to achieve, is CGMP within 6 months of getting they're going to have to extend it because it's just an absolutely asinine request, honestly.
We have a quick question about applications, background checks, and handgun owners. So really quickly, I forget what the ATF form is, but on the ATF form, you have to certify whether or not you like have used cannabis within the last X amount of years. I don't know how that necessarily applies because I don't have the form in front of me. I don't know if you have to disclose on that, whether you're involved in the cannabis business or not. But you are technically trafficking in a controlled substance at that point. But yes, typically the answer, in terms of like consuming cannabis and stuff like that is, yeah, you got to make a choice of either lying on a federal form or give up your handgun.
I actually just did a podcast. It's a quick 10-minute podcast episode on this, Jason, which it's like, gun owner, are you a marijuana user? Because yeah, it's that's what it boils down to. You're gonna lie on a form. Even if you currently have guns, it's technically illegal if you're possessing or using marijuana.
Yeah, puts people in a very awkward position, and there's no good answer, unfortunately.
And I think that it's going to just drive people to black market more so because they're going to be very, I think they'll be very reluctant to put their name into a seed to sale tracking system. For example, when you go to a dispensary, you'll have to give your license twice. And they'll put your information into a system that says you purchased marijuana that day. That's not to say that the federal government is going to come and seize those records, but they're recorded. So, whatever type of protection that is. Okay.
Well, in a similar note, I recently was discussing with a colleague who's been working with a testing facility out on the West Coast, and they were warned they're looking to get their DEA certification, and they've heard that folks who've been processing Delta 8, that the DEA, like the federal government is looking into those who are connected to the payment stubs or the COAs from processing Delta 8, and that may be something that's going to impact businesses downstream. So it's kind of on multiple fronts of like, once you apply and you're in the system and the federal government begins to look at it, like how is that going to impact your business versus what's legal on a state level versus what's illegal on a federal level. And like with this kind of whiplash around Delta 8 processing and distribution, I think it's just it's a similar kind of plug as we're talking about with like someone who's got a firearm license who then downstream may get impacted because of the federal government saw that somehow. It's fascinating.
So I actually was just talking to this guy Jeff Nemeth. He is the co-founder of ACT Labs, which is there's only ACT Labs in Wadsworth that are marijuana laboratories in New York State so far. I think a third is kind of trying to get up and running, but they're the only two that are technically medical ROs are sending their stuff to. And he was saying, one, he can't get basically it's called you can't get any federal licenses because they handle obviously marijuana, and that's Schedule 1. So he's technically in violation of federal law, but like works obviously in the confines of state law. He also said, which I find to be interesting, I didn't realize this when I was reading the bill, that New York has a really brutal lab turnaround time. So like, for example, they have like what their requirements are like 12 days worth of lab testing for microbes. And the other states like California, Illinois is like a 3-day turnaround. So we have a 12-day turnaround requirement. It's not, and I asked him, I was like, is this because we're like super diligent on like what we're testing for? And he's like, no. They're basically testing the exact same stuff, except that the requirements for New York are creating this delay, this like 9-day delay, which makes me incredibly nervous for the big issue, which was happening out in Oregon, which is just a massive bottlenecking when people are all getting licensed and ready and operating. And then all of a sudden there's only like 5 labs who are testing. And then, there's a 12-day turnaround on your samples. It's definitely something that needs to be, I think, lobbied through in the rules and regs, hopefully.
Even the licensing, like applying for a research license or lab license aside, just setting up a lab in general is extremely time and capital intensive. So you're not going to have all of these companies coming on the scene saying, oh, we're going to, be lab testing and stuff like that. Like, so if you have a limited quantity of labs plus a huge turnaround, yeah, that's going to be a massive bottleneck.
Yeah, and for Richard Glazer, yes. So this long time frame that we're talking about here is definitely a further advantage to a registered organization. And it's a little unclear on whether or not they're going to open up the ROs again for another 5, or I don't know. Jason, what are you hearing on that? Anything?
I haven't heard anything, but I mean, when we went through Article 3 yesterday, there was pretty massive requirements to open an RO. And it's unclear because of this, one-time license chance that would a future RO qualify for the adult use, the vertically integrated license, if they were to even open it up. But I haven't heard anybody saying that they are opening it up.
The interesting thing too is there's a court case happening right now with Hudson Health. They're on this appeal right now. Hudson Health, I think was, and I could be wrong, I think they're 11th or 12th in the first round of rankings for medical marijuana registered organizations. So what I mean by that is New York certified 5 ROs in the first round to distribute and cultivate, process, vertically integrate marijuana sales. Then they did a second 5-person round. And the first 5, except for one, I think, all sold their licenses. And so the premise of this court case is that like 11 and 12 are pissed because they're like, hey, if they were going to sell, we should have been one first right to offer. Like we should have been able to get first right, like a refusal, right, of those licenses. But instead, like we've been passed over, and now there's 5 or 6 new operators in the space that weren't actually ranked in the OG round. So there's a case going on right now. I don't know how much, it's Matt Schweber is the lawyer, and he's like incredibly sharp. The documents are really impressive. It'll be interesting, the ramifications if it is approved. Like, for example, if Hudson Health wins, it'll be very interesting to see what like 11, 12, 13, 14, 15 do. Or whomever has purchased it, and whether they would retroactive or just give them licenses. Like I don't think that they would make the other ones sell them back for so long, but they might say like, hey, you guys can be an additional 5 ROs.
Yeah, which would be interesting because that would add another potentially 5 times 40 medical dispensaries throughout the state if they got the additional 4 because they opened in the certain locations, and then
get the adult use. It'd actually be another 32 if they. Well, I'm sorry, it would be another. Yeah, you're right. 40. You're right. It'd be 40
medical and 15 adult use.
Yep.
So that could definitely.
Sorry, math's not my strong suit.
Let's see. We just have a quick question about what's being done at the federal level to change the scheduling. There's a lot of talk in the Senate and House. The House has passed, I think, a few bills, but the Senate's a lot more tricky because, even you'd have to get all 50 Democrats to do something outside or within reconciliation, which this is probably not reconciliation. So you need 50 Democrats plus 10 Republicans, and not all 50 Democrats are on board with legalization. So it's still a very fraught, tricky issue on the Senate side, more so than the.
So like Chuck Schumer has obviously put in a federal legalization bill, which has been talked about a lot if you're keeping up with the news. What I'm hearing from our lobbyists in DC is that bill is just kind of like a figurehead bill in order to get the Safe Banking Act passed, which makes a lot of sense, right? Because we're not going to just jump to federal legalization. That's an absolutely, in my opinion, asinine move because they don't have a decriminalization or deschedulized process. FDA hasn't taken control. So you're going to legalize it at the federal level, and it's not going to make any sense because there's no regime or anything to operate and oversee now what these other states have done. So what they'll do is most likely in increments, and the least offensive bill probably out there is the Safe Banking Bill for anybody who's kind of not sure about marijuana, which would give banking services and insurance to any state licensed cannabis business, which we're already kind of seeing. I mean, if anyone's keeping up with East West Bank, they just loaned like $250K to a cannabis business, which is a really important first step because that's never been done before. Where a bank, and it's an FDIC bank, is giving money, and that's because the legislators in California were like, we're not going to do anything. Like, we want you to be able to do this. So it's going to be, they have to do safe banking. It makes no sense that they haven't had that done yet. But
yeah.
brain.
I completely agree with that. I think federal legalization is not realistic within a short time frame, even maybe a mid-term time frame, for all those reasons. Plus, coordination of the taxes. You know, you have states taxing these things at ridiculously different rates. New York and California coming in some of the highest, and then more than likely the feds would want to throw an excise tax on top of that. So now you've just skyrocketed prices. So there's a lot to work out before we could ever get to legalization. And I don't think there's a scenario in which the Fed legalizes and doesn't seek to tax it.
Yeah.
Okay, I think we were on 6. I can take over, or if you want to keep going, doesn't matter.
You go for it.
All right. In giving notice or taking any action in reference to a registered organization or licensee or a licensed premise, the board may rely upon the information furnished in such application and any supplemental statement connected therewith, and such information may be presumed to be correct and shall be binding upon registered organizations, licensee, or licensed premises as if correct. All information required to be furnished in this application or supplemental statement shall be deemed material in any prosecution for perjury, any proceeding to revoke, cancel, or suspend the license, and in the board's final determination to approve or deny the licenses. So make sure you update the board, kind of similar to updating your service or process address with the state. If you have a business and you change locations, the state's just going to mail things out to whatever address is on file and assume that you got it. The board may waive the submission of non-material information or documentation described in the section. The waiver of such would not be inconsistent with the purposes and goals set forth in the article for any category of license or permit, provided that it shall not be permitted to waive the requirement for submission of any such category of information solely for an individual applicant or applicants. The board, pursuant to regulations, may wholly prohibit and or prescribe specific criteria under which it will consider and allow limited transfers or changes of ownership, interest, or control during the registration or license application period and or up to 2 years after an approved applicant commences license activities. Fees. The board shall have the authority to charge applicants for licensure under this article a non-refundable application fee. Such fee may be based on the type of licensure sought, cultivation and or production volume, or any other factors deemed reasonable and appropriate by the board to achieve the policy and purpose of this chapter. So that's like one factor of why I think there's probably going to be tiered licensing, and the cost of the license would depend on the tier. It's like particularly for cultivation. They're setting it up right there.
Yeah, like I don't think micro is gonna have a crazy license fee.
Yeah, although when we get to it, they do make a big push that micro businesses specifically, and I think also delivery, like should be social equity focused. So it'll be interesting to see how that kind of plays, as if, you know, is it allowed for general licensees, or is it more like, hey, we're allocating these towards social equity? Because those are the only two that make specific mention right within the section.
Well, what's important too, and I've gotten this a zillion times from people who are kind of just grazing past this bill, micro businesses do not let you have on-site consumption. So the companies that plan to be a micro business, because you're hearing this a lot from alcohol people, right? And everybody in the alcohol space is like, oh, I'm just gonna get a micro license, I'm gonna grow, and then I'm gonna sell my, you know, weed lemonade to my customers, and then they can just chill on a bar stool and like hang out. Like that's not how it's gonna work. They can buy weed lemonade from the dispensary down the street and then come drink it at your spot, but for an on-site consumption lounge. But like for a micro, you're gonna grow small canopy, you're gonna process small flower, or, you know, extract whatever you're looking to do, and then you're gonna be able to sell directly to consumer, like a farmer's market. So like somebody could like come, you might have a little sales spot with a camera and a seed to sell tracking system, computer scenario, and you could sell your flower that way, or sell your chocolate or whatever.
And other than the delivery license, which really has no guidance, the micro business has like the least guidance in this law. So like questions like, if I'm a micro business holder and I want to grow, but I don't want to have the processing facility, but I want to sell brownies or whatever, cannabis infused brownies, can I contract with a licensed cannabis processor to make my brownies and send them back to me and then sell them? I would think that the answer is yes, but we actually don't know until the regulations come out, because you can kind of read it that it is allowable, but maybe it's not. So there's a lot of unanswered questions under the
Yeah,
microscope.
white labeling is confusing. White labeling is confusing under the bill.
Yeah.
They're gonna allow.
Yeah, very much so.
Yeah.
Okay, the board shall also have the authority to assess a registered organization with a
I also
one-time.
think, just to point out, I think they did that on purpose because they want a lot of issues lobbied. Let's just put that on record, okay? So I think that a lot of stuff is ambiguous because it's just an opportunity to have more friggin' play.
Yeah.
Yeah, I also think it's like from folks like in our cohort, let's say that aren't lobbyists, it's like the opportunity to advocate for what you want and help shape the bill. It's like, as we saw, like if you checked in, with whether it be Laparda's office or Christy Stokes' office, et cetera, like you could see the bill being changed by conversations for educating and engaging. And so there's definitely the big lobby side, as well as this, like the opportunity for small businesses to come together and to really advocate, shape. The shaping process is still very much available to folks. And I think that's where it's like, now that it's legal doesn't mean that the work is over. It's only just begun to continue to now shape the regs and continue to advocate for like what you want or need.
Mhm.
Yeah, no, completely, totally true, Zach. I think even more so, this legislation is only going to be as powerful as the rules and regs permit it to be, which is why everyone's panicking about who the ED is, because they're going to be the one that starts kicking off the drafting of these rules and regs.
And interestingly, on that point, I saw an article recently that did say that Norm is the executive director. I don't know.
It did or didn't. It did or didn't.
It called him the executive director.
Okay, well, I just heard yesterday Norm's out. But
I guess the reporting was not that great.
Yeah, I heard it was supposed to. I heard it was supposed to be announced on Friday, but there's been enough pushback that it's withheld. We may hear this week who's going to be proposed, but I do think there's a lot of grassroots lobbying that was anti-Norm, and so we'll see what happens.
What I was on a panel with People Stokes, the majority leader on Saturday. Obviously, she does not want to name Norm. And then after that, I had a call with a lobbyist, and apparently over the weekend, there's basically a vote tallied around, probably because of the pushback of, was there any social equity legislative, person in the legislature who's a person of color that is in favor of Norm, and didn't get one vote. So it's hard to stick your neck out for that situation when we're talking about a bill that's emphasis is literally social equity. Like at this moment, I'd call it the most progressive legislation in the US for social equity. And that's only as effectual as who the ED is. So it could really be retroactive if it's not the right guy or girl.
Yeah, I mean, if you look at how this law is structured, everything is really controlled by OCM and the ED. And so that position is so incredibly important. And just to answer the question, who is Norm Birnbaum? He was the kind of de facto executive director, who not so much anymore. He was brought in from Rhode Island. I think he headed their medical program. And he's been he was actually very instrumental in the THC tax. That was like his thing. So even if he's not ED, he will have quite the lasting legacy in New York.
So Laura put $100 as it's People Stokes. I actually think I'll put my $100 to yours. I actually think it's either Kruger or Savino.
Really?
ED, but I think that they're going to be on the board. Yeah.
Wow.
I'm actually leaning towards Kruger, but that's my thought. I think ML's got she's got other people that she wants to put into play.
Interesting. All right, the one-time special use license for registered organizations. Such fees shall be assessed at an amount to adequately fund social and economic equity and incubator assistance pursuant to this article and paragraph C of subdivision 3. Provided, however, the board shall not allow ROs to dispense adult use cannabis from more than 3 of their medical cannabis dispensing locations. The timing and manner in which the RO may be granted such authority shall be determined by the board in regulation. So, I mean, right there, they're setting up this kind of alternate path for ROs and saying, we'll determine separately when you're allowed to do this. We'll determine a fee, and the fee will be very interesting to see where it comes in at. As I've been saying before, I've talked to people, large companies out in Colorado, telling them about this license, and we were talking about what the fees could be, and they literally were like, it could be $100 million, and they'll pay it. I mean, so I don't think New York is going to go that high, though they could. I mean, you're talking to giant companies in the second largest adult use market in the United States. $100 million is probably a cheap entrance fee to get into it. But then again, it's probably not going to be $100 million.
Yeah, good point.
The board shall have the authority to charge licensees a biennial license fee. Such fee shall be based on the amount of cannabis to be cultivated, processed, distributed, or dispensed by the location or the gross annual receipts of the licensee for the previous license period, and any other factors deemed reasonable and appropriate by the board. The board shall waive or reduce fees pursuant to this section for social equity applicants. So that's interesting, shall. They don't have discretion. So under that, assuming regulations don't somehow radically alter it, they have to waive or reduce fees for social equity applicants.
Which makes me think that the actual other fees are going to be high.
Yes.
Right? Doesn't that's how I read it. I'm like, oh, okay, they're going to waive social equity fees. That means that if you're applying not social equity, like, good luck. That fee's going to be high.
Yeah, I think that's
Not like high, like medical, but high, I think.
Yeah, I'll be very interested to see like what dispensary fees are, because there's the argument that social equity applicants could get into that, but if they're getting fees waived for it, then could a dispensary license actually be a very high fee because the social equity applicants don't have to pay it or get reduced?
Also, let's put this into perspective again. If you're applying as a producer and a processor, you have to have different licenses for each. They may say, and it's not indicative here, that you have to apply as 2 different applications for each license, which would mean non-refundable application fees for both and 2 different license fees. So, and it's again, same thing for retail stores. It could be the exact same thing for a retail store, meaning you could have 3 apps for 3 different locations. I don't think they will do that because hopefully it's one entity and then they separate it out for those 3 locations. But I don't know.
Axel said it in the CLE. It sounded like one application license that would
cover
identify
the 3
3
locations.
That's what it sounded
good.
like. Then again, he wasn't addressing that specific point, so it could have been more of an off-the-cuff statement.
Yeah, that's good. It'd be, in my opinion, just like what a waste,
Yeah.
They do that.
I mean, if we look at the hemp bill, if you're a cultivator and a processor, those are 2 separate license fees, 2 separate applications. So, I mean, I don't think it's going to be any different under the cannabis bill. I think that if you want to grow and process, it's going to be 2 different license applications, license fees, processes, and all that kind of stuff. So I think.
Laura, what do you mean? Will there be density rules around retail? Want to follow up on that? I don't know what you mean by density.
Limits on.
I imagine they mean like, like how many dispensaries.
Oh, limits on location.
Per capita.
She means limits on location. So there's 500, you have to be 500 feet away from like a playground, school grounds, park, and then 200 feet from a house of worship. So there's zoning right there. And then the local levels can also implement some requirements. They can't have like over intrusive requirements, meaning like they can't say like, hey, we're going to let retail dispensaries happen in our, like they can't opt in and then be like brutal on the opt, like where it can go and things like that. So it can't be like strenuous in terms of for the operator. But they might say, and if it's not in the rules and regulations, which I think rules and regulations might say the local zoning board will be able to dictate like how close you are to another dispensary, right? Because in my opinion, I think like on-site consumption lounges, if you're smart, you're going to be parked right next to a dispensary because you're not allowed to sell it to people. So like, why wouldn't they be back to back, But that might come down to like local, like town, like I said this before, like in Buffalo, you've got like Allen Street, which is just like a bar hub. And, that like, there's a really strict approval process of like adding new bars and things like that to that area. I think it's going to be probably similar if you're like having 2 dispensaries on a street or a dispensary and an on-site consumption lounge really close to each other. But yeah, we won't know that until a little bit more dived into the rules and regs.
But the municipalities, particularly for dispensary licenses, kind of get a yay or nay when you're in the application process, because you have to go talk to the municipality and then they send their recommendation in with the application, if I'm remembering correctly. So they can.
It's like
what's that?
Oh, so Nick's saying if it's like alcohol, it'll be one application indicating what licenses are being applied for. Yeah, the only thing, Nick, with that is like alcohol usually can be under one entity because it's obviously federally legal. There's so many other problems that we run into with state programs where everything's kind of piecemealed out. But that you might be right though that they're mirroring that application.
I think though that at least initially the state's going to want its licensing fees, and that's how it's funding a lot of the social equity stuff. And they're going to want to make a big deal of the money coming back through social equity. So I think they're going to try to boost those numbers as much as possible.
Mm-hmm.
Selection criteria. I think we'll see how far we get through this before we end. We got 5 minutes. The board.
I got a hard stop at 1.
All right. The board shall develop regulations for the use of the office in determining whether or not an applicant should be granted the privilege of an initial adult use cannabis license based on, but not limited to, the following criteria. The applicant is a social and economic equity applicant. The applicant will be able to maintain effective control against illegal diversion or inversion. The applicant will be able to comply with all applicable state laws and regulations. The applicant and his officers are ready, willing, and able to properly carry out the activities for which the license is sought, including with assistance from the Social and Economic Equity and Incubator Program, if applicable. Where appropriate and applicable, the applicant possesses or has the right to use sufficient land, buildings, and equipment to properly carry on the activity described in the application, or has a plan to do so if qualifying as a social and economic equity applicant.
Hold on, Jason. So Allison Gallup asked, do all dispensaries not allow for on-site consumption? Can you be an on-site consumption lounge and also sell cannabis products? No. You on-site consumption lounge, or you could be a retail dispensary. You cannot be both. And if you're on-site consumption, you can't sell. And if you're a dispensary, you can consume. So you can have 3 of each. If you're going to go for on-site consumption, you can have 3 on-site consumption lounges across the state. If you want to sell as a dispensary, you can have 3 locations to dispensaries.
And licensees of one can't hold licensees of the other.
Exactly. Yep. You can't even have any indirect interests. You can't even say, hey, let's be partners, right? Like say you're having like even like a non-payment, like say you have a buddy who wants to go for social equity, for on-site consumption, and you want to go for retail. And you guys had to have this deal like, oh yeah, we'll be right near each other. And we're going to put a flyer out that says, go smoke this at Tom's spot. And we're going to say the best weed is sold at Joe's spot. And you can't do that. You're not even be allowed to do that. You can't show any type of favoritism to other licensees. Even if there's no like equity to it, where like you're getting like a kickback on it.
Yeah. And because the penalties can be, severe, they can revoke a license. You can't have, you should not have these kind of like, behind the scenes handshake agreements that aren't written down. Like anything that comes up that they suspect, they're going to come in and, they can revoke a license because you're straight up violating the law. So they're really trying to silo it into, you can have this one license and that's it.
Yep.
All right. Where am I here? The applicant qualifies as a social and economic equity applicant or sets out a plan for the benefiting of communities and people disproportionately impacted by enforcing the cannabis law. That's an important one. That you're either a social and economic equity applicant, or you have to have this plan. I've also been saying, people who are social and economic equity applicants, it's a mouthful, should probably have a plan anyway, because that'll just make your application stronger. It's not required, but telling the board how you're going to benefit those communities, just makes your application that much stronger. It is in the public interest that the license be granted, taking into consideration, but not limited to, the following criteria. It's a privilege, not a right, to cultivate, process, distribute, and sell adult use cannabis. The number, classes, characters of other licenses in proximity to the location in which the particular municipality, subdivision thereof, or geographic boundary as established by the board. So right there, you know, that's what we were kind of talking about the dispensary. That's more broad for any license, but they can look at the proximity of licensees to one another. Evidence that all necessary licenses and permits have been or will be obtained from the state and all relevant governing bodies. Effective grant of license on pedestrian or vehicular traffic and parking in proximity to the location. The existing noise level at the location and any increase in noise level that would be generated by the proposed premises. The ability to increase climate resiliency and minimize or eliminate adverse environmental impacts, including but not limited to water usage, energy usage, carbon emissions, waste, pollutants, harmful chemicals, and single-use plastics. So definitely have a, you know, kind of an energy impact statement and plan. You know, we can look at that. The effects on the production, price, and availability of cannabis and cannabis products. The applicant's history of violations and compliance with laws of other jurisdictions in which they operate or have operated cannabis businesses or registrations related to the operation of the business. We are
All right, I gotta go.
All right, see you later, Elise.
Bye, see you
Hey,
guys next
see you, Elise.
Tuesday.
Thank you so much.
problem.
Yeah, how much more? Yep, we'll see you next Tuesday. And Jason, you with me still?
How much further do you want to go?
I say we could probably actually just pause it unless you want to finish up that section. I do think it's worth at least just, what's your gut say? What do you want to do?
I mean, I think we stopped at the end of a page. That's a nice little place to stop for me. So I'm good stopping there. And if if there's any questions, we can hang out for a couple minutes and answer any questions.
Yep, and we can definitely come back and like look at that criteria again. It's a good starting point as we dive back into licenses. I do want to give a big shout out to our sponsoring members. We got our founding sponsoring member, Harris Beach Law Firm, helping us keep the lights on through the pandemic. But I also got to give a shout out to our new 2021 sponsoring members, Mad Hatter's Hideaway up in Rochester, New York, as well as the Wagner firm, PLLC. These two organizations and their contributions have continued to help us and keep us inspired and moving forward. So big shout out to our sponsoring members for your support, as well as all the business and individual members who've come on into 2020.
Oh, I think Vic's internet dropped out. What happened?
I think it's dropped, so that might be a good sign for us to carry on. I appreciate everyone being on the call today. We'll see you all next week. We'll be sure to share this recording with you all. And Jason, if you want to take any more questions, I'm open to it. But yeah, you can, I'm in spotty territory over here.
Yeah, I mean, if anybody has any questions in the next minute or two, happy to answer them. If not, we will be back next Tuesday, same time, same place. Can wait for a moment, but doesn't seem like there are any questions coming.
Yeah.
What's that there?
We're good to go. Oh, there it is. There it is.
Let's see. No explicit prohibitions on white labeling that you see. I haven't seen any, but that's kind of what Elise and I were talking about, is that the law is very vague. So we need to see what happens in the regulations. I can't foresee a micro business license, for example, that says you have to process, because let's face it, processing is probably one of the more expensive, capital intensive operations, and there's licensing required. If you're using, solvents and things like that, you're going to have to get permits and blah, blah, blah. Like, that's very expensive for a micro business, especially ones that may be social equity focused, may not have access to capital. But you would be putting a micro business licensee at a severe disadvantage if they weren't able to sell processed products because they didn't have the capacity to process themselves. So I can't see a scenario, it just wouldn't make sense to me, where a micro business couldn't contract with a cannabis processor to go ahead and process somebody else's. What about for processors? I don't understand that question. Processors can process. So like, are you saying white labeling as a processor for others? I mean, I would, yes, I have to imagine that's the case, because if you solely own a processing facility, I don't think that they're only going to require you to sell your own brand. I think just like in hemp right now, you're able to process for others. I think that's absolutely going to be allowed. I just couldn't see a scenario in which it wasn't. It just wouldn't make sense. It would severely limit the processing capabilities if everybody had to have their own brand under their license. You know, I could be wrong, but I just can't see that as a scenario. Is there anything else? If not, we will wrap this up. See you next weekend, or see you next Tuesday. And that's it. So, all right. Thanks for joining us, and we will see you next week.